main laws. Really is kind of three, but we're going to talk mostly about two because the third one just kind of follows these two. We have CFR, 42 CFR Part 2, that's a federal law that was put in place in 1987. And we have HIPAA, which was enacted on April 4, 2003, right, protected health information. So HIPAA will either not change or only slightly change how we protect confidentiality. However, there are occasions where the two laws kind of overlap or conflict. So what do you do? What do you do when the two laws conflict? You take the most recent law, right, or the most restrictive law. Right? And so if neither law is more restrictive than the other one, then you would go with the most recent law. If one of the laws is more restrictive than the other one, then you always go with the most restrictive law. Okay? Okay, so these things establish legal principles. There are established legal principles to govern these overlaps. When there's a conflict, go with the most recent law prevails unless there is the other law treats it in a more focused or precise or restrictive way. Also, in case of a conflict, the law that offers the most protection for the client wins out. That's the most restrictive. Okay, so HIPAA permits disclosure without consumers for payment reasons, but 42 CFR does not. So which one do we use?
42 CFR.
42 CFR. There we go. And so we handle that how here at NAIC? How do we bill? How do we ensure that we have permission to give the billing company, the people who are going to pay us, information about what happened?
Release.
In a billing release, right? A billing release. Okay, so what's covered? Patient identifying information. That is any information that would allow you to identify the patient as a drug and alcohol consumer. And so that doesn't just mean his name, his birth date, his social security number. But if you're going around town saying something about the guy that would, allow us to identify who he is, that's protected health information, right? And so that information cannot be released except under special circumstances. All right, so there are 10 of these circumstances. First, they fill out a consent. They sign a paper saying that you can tell this person, this about my drug and alcohol treatment state, right? And we're gonna talk later on about everything that has to be on that consent. But you can rest assured that the people, the administration of NAIC has ensured that the consents that we have here follow the law. Okay, the communication is made with other staff members in your program. And so I don't have to have a consent to have a treatment team meeting with Dan and Doug about a client that we're treating. Right? It can be made without revealing any patient identifying information. We would never do that, right? But say, for instance, when Teresa gives somebody a story, as long as she doesn't give their name, as long as no one can identify that person, then she can give that to United Way. Or when we do United Way surveys, well, their name isn't anywhere on it, nor any other information that allows them to be identified in the community. So. All right. If it's made in response to a medical emergency. So I had a guy in Shirley's office one time who came up here, and he was an alcoholic, and he has a seizure in Shirley's office. And so I have to call I have to call 911 and get an ambulance down here. And so the first thing that I tell the people when they come to the door is, hey, this is a drug and alcohol treatment center. This is a drug and alcohol treatment client. I know he's an alcoholic. I tell him that because that can save his life. We tell him that, right? It can be made in response to a proper court order. Now, the word proper ought to be underlined there. So if you receive a subpoena at NAIC about a client, what do you do? Bring it to your clinical director, associate director, and I will help you understand whether or not it is a proper court order, because there are a lot of rules about when we can respond to subpoenas and what has to be in the subpoena. There is communication about a crime or a threat of a crime on the premises or against personnel. So I can't break confidentiality. The guy tells me I drove drunk last night home. Right? But if I'm driving drunk leaving from here, right, then I can't. And I'm really obligated Yes.
And crimes against personnel could be on-site or off-site.
They could be on-site or off-site, and so, and it's really just not limited to crime, it's crime or threat of a crime. And when you guys do consumer rights, we notify them right up front, hey, if there's a crime or a threat of a crime against NAIC or anyone who works for NAIC, right, you have no confidentiality.
And I also tell them that crimes against personnel could be on-site or off-site.
Yeah, it could be on-site or off-site. Okay, the communication is for research purposes, and so we have permission from an institutional review board to do some kind of research, right? Then you know, we could communicate that in a way that protected confidentiality, because IRBs will only give you that permission in ways that protect confidentiality. And of course, you guys that read rights all the time know that, well, we tell them that, you know, you don't have to participate in these research projects. Okay, it's for an audit or evaluation of a program's activities, and so under Title 43A of State Mental Health Law, DMH has the right to come out here and look at my files, whether they paid for the client's treatment or not, which they did just a couple days ago. It's made in accordance with an agreement with a business or qualified service. So here's a good example. We're going to go out to Jordan's Crossing as part of a peer review process, and we're going to review some of their client records. And then they're going to come here and review our client records. And so that's a formal agreement that we have, that we're going to do that. And of course, both of us are bound by confidentiality when we see the other people's files. It's made in accordance, involves reporting child abuse or neglect. And so we tell them that in their rights as well. You know, can't keep secret if you tell me that there's child abuse or neglect going on. I've got to let somebody know. Yes.
Regarding number 3,
Number 3.
I call an agency and say I have a 16-year-old adolescent client that I need to refer for family counseling with Spanish as first language.
Okay.
Is that a violation?
No, that's not a violation. Now, if you gave him the name, if you said, hey, his name is so-and-so, can you give me an appointment? That's a violation, unless you have a release. If you say, hey, I've got a 16-year-old client over here who has a drug addiction problem and needs a Spanish-speaking therapist. Do you guys have that available? And they say, well, yes, we do. Okay, well, let me get a release or send the guy over there. Right?
Just wanted to make sure.
Same thing we try to do residential treatment for a client, getting them to do screenings on the phone. I hand them the phone, I don't say who the client is, I say I have a client here that would like to speak to such and such agency. They're on the phone with that client. They
Yes,
talk,
that's the
I
way
don't
most,
talk.
that's the way most therapists handle that issue, right? So most therapists, you know, we got somebody in our office that needs residential treatment, we're dialing numbers for them and letting them talk to the guys, right? So therapists, you know, that's a real common practice.
We do that when we do insurance, goes on the phone too, we have the client in there while everyone else is.
Yep. All right, 42 CFR protects anyone who has applied for, participated in, or received service from any federally assisted alcohol or drug abuse program like NAIC. So that means we get a fax from DHS about, you know, referral on this client, they never showed up. Hey, you know, that's still protected health information. This next one is kind of weird here. It says HIPAA does not distinguish consumers who have applied for or no-showed from participants who have actually received services like 42 CFR does. On the previous paragraph up there, it kind of said that 42 CFR does not differentiate, and it doesn't. 42 CFR doesn't differentiate. So if the guy never showed up, it's still confidential. Okay.
And if somebody calls up and says, my name's so-and-so, and I really want to get in there to see somebody, once they tell you their name and they've called, that's it.
That's confidential. Any information you can look at this way. Any information that we have or got at NAIC about a client, that's confidential. Okay. The best way to protect the consumer's best interest, the agency and yourself, from legal action is to have the consumer sign a valid consent form. And of course, for therapists, you may have heard consult, consult, consult. If you're in doubt about anything, you ask one of your fellow therapists or your therapeutic supervisor.
I have a question about that. If a client says for us to email them, do they sign a consent for that email?
I had one the other day.
Yeah.
Clients do not have confidentiality from themselves.
But
And
if
so
it's
you
too-
can give a client any information. Now, when it comes to email, there's a lot of discussion about this. NAIC uses TLS technology, right? Transport Layer Security. And so at NAIC, all emails coming in and out of NAIC have the same security that you have when you log on to your banking website, or when you, say, go to PISIS to enter a CDC, or MMIS to enter information, right? And so all emails coming in and out of NAIC have TLS security.
But what if,
Now, when it comes to therapists, we usually advise therapists, hey, don't email clients if you can help it, because it's really easy to missend an email, right? It's really easy to type in the wrong address.
I got a help from another counselor that said, email this time to let them know that they can get into this group. So I didn't think I'd do that, so.
Yeah, you can discuss that with the other counselor. NAIC has no restriction that says you can never email a
I
client.
know.
Most therapists don't email clients because, like, it's really easy to get the wrong email address on there, you know? And then if you do that, if you get the wrong email address on there, as soon as you know, what do? You talk to me, and what do? I pick up the phone and I call the state of Oklahoma and I report us, right? And so anytime that you have accidentally or on purpose breached someone's confidentiality, you come and tell me. And me and you are gonna report you and NAIC to the state of Oklahoma, right?
The other thing is that on the consent form, when they're first coming in for treatment, and how to contact, they don't have that on the how to contact the client. And, but somebody, you know, they say, here's my email, can you email me? It's not said the consent release form, they haven't said that on their information. But later they say it, but they don't put it down. That was the issue. It's
So-
like they didn't put it on their consent form, but later said, contact me by this. That's what the council said, something like that. So if there's no consent form that they've given in writing, that's where I have a problem. So that's why I didn't.
You know, you have a license and you're individually responsible for what you do on your license. You will never, ever appear in front of your board for contacting a client when he verbally told you to contact me this way. But you get to decide as a therapist, right, hey, I'm not comfortable with that. Most therapists are not comfortable with email because it's really easy to hit a wrong key and send it off to somebody else when you're reporting yourself, right?
But it wasn't me that was given that information by the client. It was given from somebody else down the, you know, like, so that's why, and it wasn't there.
Therapists usually accept the written documentation of other therapists kind of out of hand, right? But that's your decision. Therapists have licenses, right? So they get to make a lot of decisions about what they're gonna do and what they're not gonna do. All right, to satisfy the requirements of both HIPAA and 42 CFR, consent must be in writing and it has to contain all of the following. These are described in HIPAA, in 42 CFR, and in Title 43A of Oklahoma Mental Health Code. It has to have the name or general designation of the person giving the information, right? It has to have the name of the individual organization that's going to receive the information. It has to have the name of the consumer on it. The purpose for the disclosure, why are we giving out this information? A description of how much and what kind of information will be disclosed. The consumer's right to revoke the consent in writing and the exceptions to that right. The program providing the services cannot require the consumer to sign a consent form in order to receive services. The consent form must either state the program may not condition the service based on the consumer signing, or they must provide the consequences for the consumer if they choose not to sign. NAIC does not do the latter. NAIC simply says, hey, you are not required to sign any consent to receive services here. Now, if you refuse to sign a consent to your DHS worker or your probation officer, then we will not report information to them. Now, they may have a response to that you're not going to like, and we want to tell them that. But we've had clients come in here and go, no, I'm not signing consent to my probation officer. Okay, fine, that's between you and your probation officer.
I have a client like that right now. She's under DHS and he has been telling her that he signed a release for us, and she writes us or calls me and telling me that we're not sending her the information she needs, well, I cannot tell her that he haven't signed a release because I break his confidentiality. So we kinda caught between a rock and a hard place on that situation.
Yeah, DHS workers should know what that means when they call up and they say, hey, I want to talk to you about, so-and-so. Say, I can either confirm or deny that person is a client here, right? The DHS worker should understand that that means that you don't have a release. And it's if you have knowledge that the client is here, I think it's okay to say this to the DHS worker. If you have knowledge that the client is here, and I will not confirm or deny it, it means I don't have a release. Right? If the DHS worker can't see through that, you can kind of help her out a little bit. Right?
Is that not acknowledging the client is here though? Or?
No, you didn't acknowledge the client is here. If you have knowledge that the client is here, and I'm telling you that I can't confirm or deny, that means that there's no release.
Right.
But you can do it this way. There's a way to do it without saying, without revealing that the client is a client here. If you do say that first, that can't confirm or deny it. But in general, when somebody comes to
That's what I do.
NAIC, they must sign a release of information. If they don't sign a release of information, we cannot share that information. That's what our policy is, that way they, so.
I use in general a lot.
In general,
I'm talking
yeah.
in general, this is what our policy is at NAIC. And then that way you're not directly acknowledging that, individual.
All right, you have to have the date, event, or condition upon which the consent expires if it's not been previously revoked. Right, so that's all our releases. The signature of the consumer and/or other authorized person, and the date the consent was signed. There's actually something that's not on this PowerPoint here. It also has to have a statement about 42 CFR. This is all our releases. Okay. The consent forms from NAIC contain all the necessary information. Susan and I just pulled up HIPAA, 42 CFR, and 43A yesterday and looked at all this. However, the consent forms from other organizations may not. Like, for instance, we had a guy come in here from the federal government, flew in from Washington, D.C., came down here, he wanted to research somebody's drug and alcohol treatment history in order to give them a security clearance, right? And so he brings in this form. This guy works for the federal government, right? He brings in this form that doesn't meet the requirements of federal law. And so what do? We tell him, not good enough. And so he's got to go see the guy and then come back here.
We give him more confidentiality.
Yeah, and we gave him our sheet, so go get this on. So when in doubt, right, then you come and see me or Susan, because Susan's really knowledgeable about this. Come see me or Susan or Dan, and we'll tell you, hey, this is or this is not a good release. Okay, breaches can happen in a lot of different ways. Discussion about consumers at the reception desk, in the hallways, that kind of thing. Leaving paperwork lying around on your desk for consumers to see. Last time I was at the LADC board, there was somebody in big trouble because she had given a consumer a ride and her appointment book was laying in the front seat.
Oh my God.
And the consumer picks up the appointment book and sits down looking at the appointment book. And there she is in front of the LADC board.
I found rosters in this room before. I have found pieces of paper with clients' names just kind of laid out on the thing over there. And so we really do need to be careful about that.
And, if a client or a community member comes and brings me that roster and says, I found this
Yeah,
laying in that room,
exactly.
me and you are calling the state, right, to report you and NAIC. All right, not properly disposing of paperwork. We have shred boxes over here, so anything the client had anything information on goes in a shred box, including sticky notes. Okay, the rules about confidentiality are different for different situations. This mostly involves criminal investigations in 42 CFR. And so in those kinds of instances, of course, if people's opinions, they bring them to me, right? If a policeman shows up saying, I would like to look around your building and see if so-and-so is here. Come and get me, come and get Dan, come and get Teresa. And it's happened before, by the way. All right, and we'll take care of it. So don't risk a breach. Go ask your supervisor, consult with another therapist. Any questions, comments?
But we don't, if the person insists on, a police officer insists on coming in here, you don't stop them.
Yeah, you're not gonna we're not wrestling the police.
No.
However, you can stop DHS workers who come barging in.
Oh, absolutely.
We're not gonna wrestle them either.
We're
No,
not
we're
gonna
call
call
the police,
But
yeah.
you can say, you can't come up to go upstairs.
John, what about when we're in the grocery store? Sometimes we do run into our clients. They always ask me here, why don't I just smile and I don't say anything. Tell me about how you usually handle that.
So don't be rude to your clients. Your clients don't know about 42 CFR, right? Tell your clients, if I see you outside of here, I will not acknowledge you until you acknowledge me, right? And so don't be offended if you walk past me and you just keep on going and I keep on going, right? I will not acknowledge you until you acknowledge me. Once you acknowledge me, I will acknowledge you. Say, hey, how you doing? It's nice to see you. I will not acknowledge where I know you from. However, you are free to acknowledge me, acknowledge where you know me from, all you want. And so if the client says, hey,
And they do.
hey, I was in group last night, talking about my marijuana problem, and you really helped me, and we're, standing around and outside of Target or something. I've had it happen to me many times back when I was a children's therapist. You just don't discuss it. You say, oh, well, I'm glad you enjoyed that, right? And so let your clients know, won't acknowledge you until you acknowledge me. If they acknowledge you, acknowledge them.
John,
Don't acknowledge where you know
does
them.
it apply to other employees of NAIC?
All employees.
So it's not just a therapist?
A lot of the people that come here for treatment, I did staffing for labor finders, and so they are the people at labor finders before they get caught. And so a lot of them have come in here and they're like, hey, remember you used to pay me? And I'm like, I remember you, but don't worry, I don't talk to anybody, so I can't tell you.
Yeah,
A lot of them.
Yeah.
Well, and what we tell the people in drug court is it's like, usually if you see us out in the community, we're gonna be with other people and they know where we work and even though we
They're
know,
put two and two together, yeah.
they're gonna know what you are.
I always try to explain to my clients when I see them afterwards. I mean, I'm not rude to them, I just don't really sit and discuss everything with them.
Yeah, well, I wasn't trying to accuse you of being rude. I've known therapists that have been kind of rude to their clients. Now, I live in Oklahoma City. I live in North Oklahoma City, and so I don't ever say that to my clients here. But when I lived in the same area as the facility I worked in, I told every family that came in. I did a lot of family therapy. I told every family, hey, because I frequently saw those guys outside of it. And hey, some of them would completely ignore me. And some of them would go, oh, it's nice to see you, hey, so-and-so is doing so much better, we really appreciate your help.
Cultural difference.
Yeah.
Depends on how the therapy's going.
All right, does everybody have, any other questions or comments?
I
Does
did learn
everybody have this sheet, confidentiality post